This is a John Wall Street Sports Business Brief. I'm Corey Leff. U.S. District Judge Claudia Wilken recently ruled that the NCAA cannot limit the compensation or benefits related to education that are awarded to student athletes competing in Division I men's and women's basketball or football's bowl subdivision. The ruling means that schools previously limited to covering the cost of attendance, plus some other expenses like meals for student athletes, can now reimburse them for items related to the pursuit of various academic studies. Things like computers and music instruments, science equipment, and tutors. Back in November, the NCAA settled the damages on the antitrust claim for $209 million, a total meant to account for the difference in the value of a scholarship under the NCAA's previous bylaws, and Wilken's revamped understanding of what it entails for 50,000 current and former student athletes. The premise of the claim filed by former West Virginia football player Sean Alston is that NCAA rules restricting the amount that schools can pay student athletes is anti-competitive and suppresses what they would otherwise command on an open market. So while permitting additional benefits provided they're tethered to education is certainly an incremental increase, it fails to help collegiate athletes achieve their true market value. Remember, the plaintiff's main goal here was to eliminate all restrictions. Considering the court's ruling upheld the NCAA's amateurism defense against antitrust legislation, it's hard to argue that they're not the biggest beneficiaries of Wilken's ruling. The reimbursement of education-related expenses is a positive change that will be welcomed by college athletes unhappy about the disparity between the extraordinary revenue generated, like the $19.6 billion in March Madness contracts through 2032, and the modest benefits that they're afforded. But it's unlikely to satisfy them. There's simply no amount of educational expenses that could ever get the players close enough to the $1 billion a year that the NCAA makes on the other end. There's just no way that the expenditures could ever be high enough to capture the true market value of the top athletes. Speculation exists that tethering compensation to education represents the NCAA's last-ditch efforts to refrain from paying student athletes. But there appears to be room for further negotiation between educator-related expenses and an unregulated market. A court could put nominal caps on the dollar amounts. Judge Wilken initially tried to do that in the Ed O'Bannon case. Of course, that decision was overturned by the Ninth Circuit Court. Don't expect the ruling to have much of an impact in the short term. The NCAA has 90 days before the permanent injunction goes into place, and it's currently stayed pending appeal. And some believe that the case could ultimately go all the way to the Supreme Court, in which case it would be years before a resolution is accepted. If you're looking for more sports business news, sign up for our free daily email newsletter at johnwallstreet.com and follow us on Twitter at HowieLongshort. Remember, new episodes of John Wall Street Sports Business Briefs are released Monday and Tuesday mornings at 11 a.m. Eastern